Hi everyone, this is Joseph. We're doing TikTok Live here at the Asian American Expo. It is the largest Asian American Expo in the United States. There are estimated to be 20,000 people that are going to be here visiting. I'm here. This is our first time being a vendor, opening up these spaces and answering people's questions on immigration. Today, we're mainly going to start talking about E-2, right? The investment non-immigrant visa. So not the green card investment, but the non-immigrant visa. People say it's like the mini green card because it's in some ways better than a green card in a lot of the situations. And so we're going to be talking about that because we've helped so many people do the E-2 visa to come to the United States, open up the business, stay in the United States, live here for 5, 10, 15, 20, 30 years on the E-2 because it doesn't expire, right? And the good thing about it is also when you're on the E-2, it's not worldwide taxation. That's probably the biggest benefits to the E-2 visa compared to a green card. So a lot of people prefer the E-2 over the green card. A lot of people don't know about it. And it's pretty insane because it's arguably the best visa category. Let's talk about the benefits. One person applies for the E-2, the spouse gets the E-2, the children gets the E-2, the entire family can come over. The spouse of the E-2 can work any job, can get any work permit, can work for any job. It's not limited. So unlike H-1B, unlike a lot of other visa categories where the spouse cannot work, the E-2, the spouse can work. So both people can work. That's number one. Number two, when you do an E-2 investment, you're not tied to the job like an H-1B, like a TN, like an L1, where you have to go to the office and you have to work your specific role. And if you change locations, if you change your job duties, you have to file an amendment. An E-2 investor, you're the boss. The government actually doesn't want you to work. They want you to invest and hire and build and let go, right? You make your money from the business, but they don't actually want you to work. So the most traditional example of this is like, let's say you're a dentist. They don't want you to start a dentistry and then be the dentist themselves. They want you to hire a dentist to work and you're just like the manager or the overseer or the visionary and the entrepreneur. That's the goal of the E-2. So that's some of the key benefits. You invest, you start a business, and you hire people. You're not tied to it. Your staff, your spouse can be a staff if they want to, or they can work somewhere else, and that's totally fine. Your children can come here, they go to public school, and you don't have to pay worldwide taxation. So those are some of the key benefits of the E-2 and why a lot of people do it. But I'll be here answering any questions and let me know what thoughts you have.
I'm on H-1B. Active F1 STEM OPT, until 2027. I'm being applied for H-1B this year. Can I travel during the summer?
So you're on OPT this year. You're gonna apply for H-1B this year or next year. If you are not selected for H-1B, if you didn't get the H-1B yet, keep the OPT going because you're on OPT extension until next year, right? So keep the OPT status. You can travel. Just on your way back, be prepared to explain to the customs officer, hey, I'm on OPT, I have a job, it's bona fide, it's real, I actually do it, I have pay stubs, ideally. I have an employment letter if you ask. We have a bunch of OPT students at our firm who've left and coming back. Even H-1B, they still check that as well. So be prepared to explain everything and you should be fine.
What is an R2 green card holder?
What is an R2 green card holder? I'm not sure. R2 is a religious visa, and R2 is a religious visa dependent spouse. So they're not a green card holder. But if you could go from an R2 and then you can apply for a green card through the EB4 program, I mean, the R1 individual can apply and then the R2 can get it. So I'm not sure if that's the thing. Unless you're talking about your green card has an like IR2 or R2, that I think you just search up on ChatGPT and they'll give you the direct definition of it.
I see. And these are some of the YouTube comments we get. If I get H-1B,
yes,
can I have both F1 and H-1B active until 2027? I'm trying to travel.
So let's say you are an F1 international student, you're on OPT, your visa is still valid, you apply for the H-1B, and it is, you get selected, you file it with USCIS, and it gets approved. You leave the country. If you do not go to the consulate to get a new H-1B visa, when you come in, you have to come in as an F1. If you do go to the consulate and get an H-1B visa in your passport, now you have two. When you come in, you have to make sure the CBP officer at the airport lets you in on the right visa. Because if the officer lets you in back on the F1 OPT, suddenly that's a big mistake and that's not good. So hopefully that answers your question.
Are students still getting their STEM OPT?
Yes, STEM OPTs haven't been canceled yet. OPTs haven't been canceled yet. It is on the chopping block. It is something that USCIS wants to cancel, but they're taking baby steps. So right at tail end of last year, they're starting with trying to decrease the day one CPT schools, a lot of their reporting. In the future, when people are applying for work permits, they're gonna scrutinize it a lot more, but that hasn't happened yet, but you know it's coming.
Can I travel out of the country if I owe child support?
Can you travel out of the country if you owe child support? Unless there's a warrant out against you, leaving the country, there's no mechanism to stop you. So I think what you're asking is, in a very severe scenario, your passport can be invalidated. But that takes a very severe situation where there's a warrant against you and your passport is invalidated, and then the airlines won't allow you to board. That applies to sex traffickers, child support, misdemeanor, certain felonies, generally not, right? Where in the sense where you get to the airport and they confiscate everything and don't let you leave. It's a very rare situation. However, when you come back into the US, when you see a CBP officer, then there might be more scrutiny, especially if you're a lawful permanent resident or you're non-immigrant, right? So if you're just on a visa, if you're just on a LPR status, green card status, and you owe child support, and there's a warrant out against you, that is much more where you're concerned. But just leaving the US, there's usually very little grounds to hold you.
What about EB2 visas when doing master's degrees?
Yes. What about EB2 visa, master's degree?
Does it happen? Is it possible?
It's still happening all the time. We just got like 5 or 6 cases approved, and that hasn't been stopped. It hasn't been canceled. Now, if you're part of the 75 countries that got banned, even if you got an EB2 approved and you're at one of these embassies abroad, then you're out of luck, right? Those visas are on indefinite hold. So if you're in one of those situations, we're part of the 75 countries that got banned, you should get back into the US on a non-immigrant visa and then adjust status in the US. But EB2s are happening, EB3s are happening. The US still is in desperate need of a lot of workforce. So that is just happening all the time.
Can you still do H-1B consulate stamping, the initial consulate stamp, in another country aside from your home country?
I do not believe so.
On F1 visa, my employer filed EB3, but I'm from one of the 75 countries. Can I adjust my status and get EAD?
In the US. So if you are in the US, congrats. When you file if your priority date is current, so you can file the adjustment of status and you can file for the EAD and you can get the work permit, right? Now, if you're part of the 19 countries, right? So there's 75 and then there's the 19. If you're part of the 19 countries, then potentially the EAD will be denied.
So the EB3, you don't need to go to the consulate abroad?
If you're in the United States on a non-immigrant visa, tourist visa, F1 visa, H-1B visa, some sort of visa, if you're in the United States and your priority is current such that you can file for adjustment of status, then you can do that. The 75 country ban does not affect you. It only affects the people who are abroad.
Do you think this pause is going to be in effect for years or for months?
In my personal opinion, I think it's going to be there all the way until the end of the Trump term. So next 3 years. I also think there'll be more countries that will be added. I also think that whatever policy that they create, because this whole thing is about public charge. So they're going to look into the public charge, and then whatever policy they create from there, they're going to apply it to hundreds of other consulates around the world.
What happens when you're detained by ICE?
The first thing ICE is doing is going to double check if you have legal status. So whether you are a US citizen, if you're a green card holder, if you're a non-immigrant, if you are unlawfully present, they want to double check if what you're saying is true, because they don't know. So they'll bring you back to their the field office, and then they will double check with Department of Homeland Security. They will double check with USCIS, because they themselves No other agency in the United States have access to your immigration file other than USCIS. So ICE actually has to pay USCIS to get your record. And that's why if you are a US citizen and if you are a green card holder and you don't present that, and then they have to check and they have to pay, they will fine you. And that's already happened, right? It happened in Chicago. It definitely happened to one of our clients. And so be extremely aware. If you are a US citizen, if you are a green card holder, carry your documents with you. It's extremely rare. It's extremely, extremely rare, but we have seen it happen. And the unfortunate thing, what's worse, is if they detain you and you don't speak English and they don't even know how to track you down, you might be detained for 2, 3, 4, 5 days as a US citizen or green card holder for them to eventually find out, oh, you are telling the truth. And then they let you go. But they had to house you for multiple days, right? And so it's a big cost to the ICE agents. So that's the first thing that will happen. They have to double check if you are lawfully present. If you are not, well, then the next step is, okay, they create an NTA, no notice intent to appear. They create an immigration file. Now you're going to be deported. And now to see whether or not you can be bailed out, right? So you can apply for a bond if you qualify. And they make a determination if there's a mandatory bond or not a mandatory bond.
Can you be detained by ICE if your 751 is pending?
No, because, well, in the sense of you already have your green card, it's expiring, you file 751, you get the original receipt showing that your green card status has been extended by 2 years, 3 years, or 4 years. And when you carry that, if you can show that to the officer and they believe you, then you won't be detained. But if you don't carry it, you say your 751 is pending and your green card is valid, your status is valid, they don't believe you, they can still detain you and bring you in to double check, right? I'll answer 2 more questions and we'll do a quick walk around so you guys can kind of see the environment. It's super festive right now, so pretty cool. But we'll show you real quick and then we'll come back and we'll answer more questions.
Now, if I heard you correctly, if you're from a partially banned country, you can't adjust your status in the United States. Is that right?
What I'm saying is the 75 country ban is banning consulates and embassies from giving immigrant visas. So if you're a part of the 75 country, you can still get non-immigrant visa, but you can't get immigrant visa anymore. It doesn't matter if you are a family-based or business-based, you cannot get those anymore. So you have to get a non-immigrant visa, come to the US, and then you can apply for adjustment status in the US. So that is the 75 country. The 19 country is even more strict. They're not providing any benefit requests. So work permit is a benefit request, a green card is a benefit request, citizenship is a benefit request, a travel permit, advanced parole, reentry permit, all benefit requests. So if you are applying for benefit requests, those things are hard lockdown. So 19 country, super hard, doesn't matter if you're doing it in the US or abroad. But 75 country is just purely immigrant visa.
And K1 is counting as an
K1
immigrant?
is counting an immigrant visa from what we've seen. We haven't seen anything that counters that yet, but it is my suspicion that K1 visas will be held. You will still get the interview. You can still go to the interview, but maybe the immigrant visa just won't be issued.
What do you think the H-1B lottery chances this year are for pay level 1, STEM OPT, engineering field?
From everyone that I'm talking to within the immigration world, a lot of people are thinking the lottery will shoot up to maybe 60, 70, 80%. Some people are optimistic to the point where saying there won't be any lottery. Basically, everybody who applies, they will get selected and you can immediately file. We'll see, right? In the past, 30% is already really high of being selected. So going from 30 to 90 is already a 3-fold increase.
So where are we today, Joseph?
We are at the Asian American Expo, and this is our booth.
Yeah, let me
Check
show you
it
guys
out.
the booth.
Check out our booth.
We have a little banner. This is our little lighting setup.
Yep. And I'll take you guys, we'll walk around this way just to get a feel of what's going on. People are selling medical supplies. People are selling life insurance. People are selling soy sauce and hot and sour. And this is a cargo ship, logistics, massage devices. People are selling air conditioning, water filters, air purifiers. The list goes on and on. This is like a super Costco.
And where is this?
This is in Pomona.
Yeah, Asian
California.
American Expo in Pomona.
Yeah.
If with DACA, if someone asks
Yeah.
if I'm a citizen,
Yeah.
do I need to answer or can I remain silent?
I would recommend you answer, I am on DACA, I'm lawfully in the United States. But also it depends on the context, right? So if, let's say you were here and you're walking and then suddenly an ICE agent stops you, you're not being cornered, you're not being arrested, it's super loud. Just, if you're not being detained, just keep on walking, you know what I'm saying? But let's say you're driving in a car and suddenly there's like 5 ICE agents that surrounds you and you're being cornered. And if you remain silent, well, what are they gonna do, right? They have to assume that they have to arrest you, right? That's all they can do. So if you are on DACA status and you've been cornered, I would say, hey, look, I'm on DACA. I've been here for like 2 decades. And then you explain what you're doing and that you're lawfully here. And if you have the documents, you can show them. That's my recommendation. If you're unlawfully present, that's a different story, right? So one reason why we're here is we really want to show people what an expo is like. We've done so many E-2 cases where we recommend clients to go to different expos, different trade shows. Why is that? Because here's the requirements to submit an E-2 case. First, you want to invest in your company. Some people invest 50,000, some people invest 100, 150, 200, 250, but you invest money into your own bank account, your own company's bank account. Nobody else's, your own. Once you invest, you need to start spending it. You need to spend it to prove you're building up the business. Spend it on your website, spend it on your Yelp page and advertisement, spend it on your staff, spend it on your computer, your phone, your car. Spend it on things to show that you are now building up your business. But what else can you spend with a good ROI? It's these trade shows, because these trade shows are relatively inexpensive, right? A few $1,000s, set up a booth, multiple days, you see 10,000 people, depending on your customer base, right? You could choose your ethnic, you could choose your field, right? So maybe let's say you are in an air conditioning business. Well, maybe you could go to air conditioning trade shows, and there's other suppliers and advertisers that you can work with them. So there's so many different trade shows that you can attend. Set up a booth, and when you set up a booth, there's all these other little costs that add up, right? So for example, the furniture, the gifts, you know, we're giving out cups, we're giving out Krispy Kreme donuts. So there's all these expenses that kind of add up. Having the right expenses is really important because the officer wants to see that you are actively invested in the business and you actively spent it, right? So if you invested, you know, $100,000 and then you buy a $90,000 Mercedes, well, that's really hard to justify how you're building up the business, right? But when you go to a trade show, all these little expenses add up and you could really demonstrate, look, I'm really actively investing to build up my company. That's what I'm trying to do. And you have all these receipts. And then once you're here, you're gonna meet customers, you're gonna meet other vendors, you're gonna get business cards. All of that becomes really strong exhibits and evidence to show that you have now the network and the future business to be able to launch. Now, just because you go to one trade show doesn't guarantee your E-2 is gonna be successful, but it definitely helps significantly, right? So you invest in your business, you wanna have a good business plan to show how you're gonna sustain this business, how you're gonna be able to make enough money so that you're gonna pay yourself the salary, you'll pay the staff's salary, and that the business will survive and it will continue. That's all critical to the success of an E-2. And going to these trade shows, finding partners, finding key people that you can invest in and partner with, and get letters of support, emails, all super, super helpful, right? And so those are the things that you wanna keep in mind. And that's why when we tell clients to go to these trade shows, but we've never been to a trade show. So this is the first time here. It's Chinese New Year. We're celebrating. It's fun. It's exciting. So that's why we're here, right? And now we got a firsthand experience coming here on a Friday, setting everything up, you know? So these are the things that we're thinking about.
Do you think this K1 visa will 75 country effects the K1?
Yes.
Yeah, a lot of questions about this.
I definitely think so.
Do you think the 19 country travel ban and processing pause, do you think that's going to have a chance of spillover green cards to China and India?
You mean the
19 country USCIS pause. Will that cause a spillover for green cards toward India and China?
Yes. So let me explain. The 19 country pause on all benefits. So people are not getting their visas. Then people are not getting. Then those visa numbers from those countries are not being used. The 75 country ban also, if the consulates do not issue those visas and the people do not fly into the US to adjust status and do not use up the visa numbers, then all of them, their visa numbers will pour over into the business immigration world. Okay? So it doesn't directly go to China, India. It goes into the business immigration world pot. But then it will flow to EB1 category first. And EB1 category, the people who have the most backlog, is China and India. And then once the EB1 category gets filled, then they go to the EB2 category. And again, who uses it the most? India and China, right? And so in a way, the biggest beneficiary of this 75 country ban, the 19 country ban in the family world is really China, India, EB1, EB2 applicants who have a backlog.
Now, this is in response, this is a comment on our 19 country travel ban and processing pause.
Yes.
Our live last time. USCIS officers do not need to wait to receive all the documents to deny the application. So even one ineligibility evidence is found, the USCIS officer can deny the application.
That is correct.
So we said that the ban actually could help some people because now you have more time to prepare documents.
Right, I see. That's regarding the previous video. So that is assuming the cases that are filed, USCIS officers immediately adjudicate it and they can deny cases if it's insufficient, right? So for example, if they see like, you have a public charge, you have a criminal record, they can deny cases. I was saying, certain things that are missing. For example, let's say a birth certificate that's missing, which we see a lot of these cases. If a birth certificate is missing and they were going to deny it, a lot of times we're saying they don't deny it because once you file it, they just put it away. They don't want to spend the time to adjudicate. They have higher priorities. Since it's paused, they don't want to focus on it. That's from my impression and from what we are seeing. Can USCIS still go through and deny all of them? Of course they can. Are they going to? Are they doing it? In my opinion, they're probably not. And so it might be a benefit. So they don't have to file for a motion to reopen.
So yeah, feel free to any more questions on TikTok. One interesting comment, this is denaturalization, right? If naturalized citizens are getting denaturalized for a mistake on their form or committing fraud on their initial form. Are you with me so far?
Yeah.
No question, but this is the context, okay?
Right.
It changes what it means to get U.S. citizenship because if a born U.S. citizen commits fraud, there are laws that apply to that, right? They go to jail. Whereas if you're a naturalized citizen and you commit fraud on the form, now you're getting deported. So it's almost creating a two-tier justice system because the punishment is different. What do you think about that?
It has always been this way, and very likely in the next decade, 2 decades, it will probably always be that way continuously. Non-immigrants, if you are not a green card holder or visa holder in the United States, you have very, very low rights. Once you become a visa holder, you have a little bit more, but still barely any. You have a green card, you have more rights and responsibilities, but you still don't have the same rights as U.S. citizen. And once you become a U.S. citizen, again, if you denaturalize, then you don't have the same rights, right? And so the whole concept comes into, you're a citizen. Oh, are you born or are you sworn? That's the kind of idea, right? Because if you naturalize, if you are sworn to become a U.S. citizen, well, they could denaturalize you and suddenly you have even less rights. So that has always been the case in the United States system. Will it change? I don't predict it will change, as in it will completely go away. Should it go away? It's a very big political public policy discussion. We could dive in deep to talk about it. I don't think Congress will buy the argument that everybody is created equal and therefore should have all the same rights from top to bottom. So That is something to really think about. But you are absolutely correct. If somebody commits fraud as a U.S. citizen versus you denaturalize, you get deport them, there is a two-justice system.
When taking the N400 citizenship exam in Chinese, should I fill out the forms in Chinese or English?
You should definitely fill it out in English. You can sign in Chinese, your signature. That doesn't matter as much. But the form itself should be in English because that's what the U.S. officers are looking at. But I'll take it one step further. You should probably do it online, right? Because now that system has been somewhat optimized, very few glitches, you can upload documents, it's cleaner. You should probably directly do it there. So the officer has everything.
My relative got a green card through DV and stayed in the U.S. for 4 years. Then he left, stayed abroad for 16 years. His green card has been expired for 10 years. He now wants to renew his green card and come to the U.S. to settle his son. Is that possible?
Highly, highly, highly unlikely. It is extremely difficult. When you file for the I-90, first there's going to be a biometrics appointment. A lot of times we're seeing this year, I-90, they're going to say you've been out of the U.S. for 1 year, prove the U.S. is your home. So it is highly unlikely the I-90, the green card renewal will get approved. It is highly unlikely when you see a CBP officer and you explain your situation, the officer will let them in, especially in this climate these days. Our craziest case was when a person left for the U.S. for 13 years and then the officer still let them in. That was a case that we worked on. Another case, I think it was maybe 15 years. The client straight up gave up the green card, as in they didn't even think about it, but they've been married to a U.S. citizen for 20, 30 years. He was I think 70. They were coming in with a new I-130. The CBP officer was generous enough to let them in, but that's a miracle case. So in this situation with the DV visa, if you're asking me, the success rate is probably less than 1%. Do miracles happen? Can you try? Go for it. What's the worst thing that happened? You're forced to abandon it on the spot and reapply, right? The thing that I mainly want to start talking about is the H-1B self-petition. I think that's something that is quite important that a lot of people don't quite have a handle on because it is so new. One of the things about it is, unlike an E-2, unlike an L1, an H-1B self-petition, you don't have to be managerial. You don't have to be the owner, right? So for example, for L1, they don't want you to be a first-line supervisor, meaning if you start a company, if you're managing the store, if you're managing a few employees, they don't want that because you need to be an executive, right? You need to manage other vice presidents, other managers, other general managers, and they manage other people to get the work done. If you are there signing contracts, if you are there serving clients and customers and patients, then you are not an executive, you're not a manager, you're not an owner, you don't qualify. So that's the problem with a lot of L1 applications. E2 applications, you are an investor, you are the visionary, you are the entrepreneur. You are not supposed to be doing the work. There's pros and cons to that. But for H-1B, you need to be the worker. You need to be the special occupation worker. And that is a somewhat contradictory situation when it comes to a self-startup, right? If you are doing a startup, you are a founder, entrepreneur, how can you be the specialty worker? Well, it's the exact same problem in reverse. If you are an L1 or E2, you are the founder. Well, if you're the founder, but there's no other employees, how can you be the founder? Aren't you the worker as well? So that's why in the immigration world, they give you that kind of grace period. For L1s, it's typically for 1 year. E2s, they don't really give you a grace period. But for H-1B, they give you this first 18 months. Okay, we understand you're doing these dual roles. You're doing a self-petition, you created your own company, you are the owner, you're petitioning yourself, you want to be in the US, you want to do this thing. Good for you, go try. 18 months. For L1s, 1 year. We'll let you do it, but for L1, your goal is to build up the company so that you become an executive and you manage other people. For H-1B, you are supposed to build up the company so that you can have other managers and you do the work that you're supposed to do. It's a very interesting opposite situation. but it's the same idea. Now, this is revamped. Since last year they opened it up, made it a lot easier. They created that 18-month process. So it's a lot better. And for a lot of people who are on OPT, or if OPT gets canceled, which is very likely going to happen in the next few years. So if you're a college student, if you're if you're in your master's degree, if you're banking on after you graduate, you can get an internship and stay in the US for an extra year or extra 3 years. Just be prepared. USCIS, the government might start canceling the OPT or make it a lot more strict. And if you don't have a job lined up that's willing to petition for your H-1B, maybe the only opportunity you have is to do a H-1B startup, to start your own company, petition yourself. And you might be asking, how much money do I need to invest to start my own company? What am I going to do? Well, that's very interesting. Right now, we just did a case, and just sharing the facts with you, right? We did this live last time. The amount of money that our client invested is the same, exceeding a little bit, by his salary that he needs to pay himself, because we want to overcome the ability to pay issue. So based on the Labor Department, he needs a salary of $120,000 for his H-1B role. Okay, so he invested $120,000. Now, any business owner would know that's not enough, right? If your one employee salary costs $120,000 and you only invest $120,000, what about the rent? What about the marketing? What about the website? What about the CPA costs? What about the lawyer costs? What about all these other costs? That's purely not enough. So the idea is, well, at least I invested the same amount as my salary, and I'm going to ramp up the business fast enough so that there will be a positive cash flow, so I will be able to afford my own salary. That is the idea of the H-1B startup. It worked, the case got approved. He was a business development specialist. He's creating business for other businesses, not marketing, business. So business development, he creates new partnerships, he creates more marketing, he creates a better logistic process, he creates more business for other businesses, and he's going to sign up a lot of clients, and that's how he gets his revenue, and that's how he builds up. If it's an L1 company doing that, it's actually quite hard, because then you need to hire a lot of business development specialists to do that job, right? But he himself is the business development specialist, so he just needs to hire a manager to coordinate schedule. You see what I'm saying? So that's the H-1B startup. A lot of people who have visited the booth, they're asking about what happens if their green card, what if they left the US with their green card for several years, right? And so a lot of people encounter that and have those issues. And again, what we're advising them is you first want to pick the best a CBP entry, right? So New York, California, Mexico border, generally some of the best CBP officers that I know, some of the entry points. And the reason why is you want to enter when there's a customs officer that knows your background, that knows what people like you go through, right? And so if it's a smaller airport and nobody in that community leaves the US for over a year or 2 years, then it's very strange that you've left for 2 years or 3 years. And they don't even know how to question. And the law is clear. If you left for over 6 months, we should have applied for a re-entry permit. If you left for over a year, well, you might have abandoned it. But people in New York, people in California, that's a common thing where people leave all the time. And so the CBP officers understand that much more easily. And, the Mexico border, again, they understand that. San Diego is extremely expensive to live in. So a lot of people live in Mexico and they come back and forth, right? So that's the goal, that's the idea. It's not like, there's a special situation where, New York and California, it's just like granting paroles where they don't, right? But it's because the demographic, right? They understand that situation. The goal of the green card reentry is to show the officer, US is your home, and the reason you left the country is for a temporary, limited purpose. You don't want to say things like, oh, the US is too expensive, or I don't like gun laws here in the US. Well, that's not limited and temporary, right? It's been part of our founding, right? So you definitely don't want to say anything that's like that. You could say something like, oh, I had to inherit a business overseas and I needed to close it down before I come back to the US, or I just got my green card, I'm not ready to transition everything over yet. Or you can say something like, oh, my mom passed away, or my uncle passed away, and I need to take care of a lot of family business. Those are reasons why you need to leave for 3 months, 6 months, a year. That's understandable. But you left the US, you got married, you had kids, you started a business, you don't like the US, you say all sorts of things that's derogatory against the US on your WhatsApp, on your WeChat, that seems kind of strange. It doesn't seem like the US is your home, right? So you want to have a good temporary reason abroad, and you want to have documents to show that US is your home. Did you renew your driver's license? Did you, do you have a retirement account? Do you have like a home? Do you pay your taxes? These are the things that they also care a lot about. So those are things that you want to present and you explain to the officer, and you don't want to take all your documents and just shove it to the officer. They want to be able to ask you and you answer, right? So when I go with clients and we explain this to the officer, we definitely rehearse and practice, but it's the two of us answering the questions, but we have all the documents with us, right? For example, the client that left the US for 13 years, I had 13 tax returns, right? It was like this big. I had to bring it all. And the officer was able to understand that and let us in, you know? So it's a crazy world that we live in. And a lot of it depends on how you build your case. It is not a math equation. You left the US for a certain amount of days, you pay a certain amount of taxes, therefore you qualify, therefore you don't qualify. It's up to each individual officer's discretion. The US is a democracy. The consular officers, the USCIS officers, the CBP officers, they all have a lot of discretion. So it's up to you when you face the officer to be able to explain to them and to convince them whether or not you abandon your green card or not. They are going to use their own personal judgment to decide if you've truly abandoned your green card or not, right? So definitely how you interview is paramount so that you can be able to explain to them. And again, what documents you have, right? You could be the best talker, but if the officer asks a few questions and, you know, they see right past that, then there's a problem, especially if you lie.
Can a green card holder married an immigrant that didn't enter the country through port of entry?
Green card holder marry a foreigner, petition them,
And
then
the foreigner entered without inspection.
and the foreigner entered without inspection, so EWI. So now there's two paths for you. Path one, the green card holder becomes a citizen, petitions, well, I don't know if the I-130 has already been filed, but you can file the I-130 and then do the waiver, the 601A waiver, and then the spouse would be able to go to the consulate, get the green card, and come back in, right? So that's one path. Or if the green card holder doesn't become a U.S. citizen, then just directly do the I-130 and do the 601A waiver. But because you're only a green card holder, your priority date is a little bit longer. So you have to wait an extra maybe 2 years or so. So that's the thing that you have to keep in mind. So it's still possible. The combination is I-130 and then the 601A, assuming there's no other reasons that they were barred. And then you wait the time period, you win that case, you go to overseas, you get the green card, you come back.
Correct. Well, what if you're a green card holder and you haven't left the U.S. in 16 years?
That's fine. That's a plus. It'll be a negative if you got a green card and you left the U.S. for 16 years. That's a much harder argument, right? Because in the 601A argument, you're arguing that don't separate me from my wife, right? Or spouse. Don't separate the two of us. But if you've left the US for 16 years, then the officer will be like, well, then just go together, right? Why should I grant you this waiver and grant you this green card? So green card holder, been in the US for 16 years, wonderful.
Now, how is the ban on the 75 country ban affecting I-140 and AOS that's already been filed?
Great question. The 75 country ban is banning visas abroad. So it doesn't affect the adjustment of status at all if you filed it in the US. Now, you might ask, well then, what happens to my case if it's already filed? Nothing. It's just going the same exact path. That ban doesn't slow it down or speed it up in any meaningful way. Maybe what you might be concerned about is that whatever policy that the Department of State comes up with, because this whole 75 country ban is a testing ground. They're testing how should we adjudicate public charge. And whatever policy that they come up with based on this pilot program, they will probably implement across all the other consulates, and they will take that and apply it to adjustment of status in the US. Now, USCIS moves remarkably slow. So whatever policy that they come up with might not affect you because by then you already got your green card, right? But if it's half a year from now, it's a year from now, then you file the adjustment of status, maybe the new policies will be in place. So that's how it will affect if you are in the United States filing for adjustment of status. If you are not in the US filing for adjustment status yet, and you are flying here to adjust status, well, do it as soon as possible, right? You need to come in with a non-immigrant visa in order to file the adjustment of status. If you're part of the 75 country, you probably don't have a priority backlog on the I-140 business immigration side. And if you do, then the 75 country ban will probably speed it up, so it'll be faster, so you can file adjustment of status if you are EB1 or EB2. I don't know if that's your question, but feel free to ask. We did a lot of in-depth analysis on the 75 country ban. Almost everybody who are in the US, they want to come to the US to do adjustment of status. There are very, very few people who are in the US, they file the case, and they want to or have to go back to their home country. There are some cases, for example, if you don't really want to be here for that long, and people who get the green card, they want to file re-entry permit and leave immediately because maybe they have a good job overseas, they want the green card more so as a backup, as a better visa that they can travel in and out of the country, right? So certain people don't want to stay in the US for that long, so they go back to the consulate. Other people, they have to go to the consulate to get the visa to come back, and that's the 601 waivers, right? So in order to get the waiver, they have to leave the US and then come back in.
Can you explain a bit more like why the 601A waiver?
Yeah, you apply for a waiver. In the past, before 601A, before 601, you technically had to leave the US and file the waiver outside of the US. But nobody does that, right? Nobody wants to do that because it's like, well, then that's like giving up already. So 601A allowed for people to file the waiver in the US, and once it's approved,
Yes.
then you leave the US to go to the consulate, get the visa, and come back in. It's supposed to be for formality. Of course, there are major horror stories of people getting a 601A approved, the waiver approved. They leave, and then they get stuck abroad. That it rarely happens, but it has. So you definitely want to prepare and explain everything well.
Is it true that applying for I-140 with premium processing triggers an RFE?
No, absolutely not. Absolutely not. And I cannot be more clear about that. At our firm, we encourage everyone, 99% of the people, to file a premium processing. 99%. There are only a few cases where for strategic reasons, like you want to freeze your child's age or you really don't need it, then maybe you don't do premium processing. But almost every single case, we encourage it. It is better in so many ways. I know it's more expensive. I know sometimes you get an RFE. I know sometimes you don't get RFEs. There's so many cases that we publish, and again, almost every success story we will say, we filed it approved without RFE. We filed approved without RFE, right? So we share, most cases don't have RFEs that we file. So it's definitely not true that you get an RFE,
So
right?
you've
That's,
seen premium process cases without an RFE?
I don't know, more than 50%, majority of them don't have RFEs, right?
Okay. What about cases that have been filed already for my parents, and they are among the 75 countries that are banned?
So your parents, I presume they're overseas. You filed for them, so you presumably filed the I-130. The I-130 will get adjudicated. The NVC process will continue just like normal. The consular process will go through like normal. They will be called in for an interview just like normal. The only thing that changes is they won't get the visa and their stamp to come to the US. Now, with that being said, if you want the green card ASAP, are you able to get them a non-immigrant visa to come to the US first and then adjust status in the United States? That's what a lot of the clients that we are representing are doing from the 75 countries. So for example, you're doing an I-130 petition for your parents so that they can get a green card. If they're in their 40s or 50s, are they working? Are you able to get them an H-1B visa so that they can come to the US? Because that allows for immigrant intent, right? Can you help them get them an O-1 visa so they come to the United States and so that they could adjust status in the US, right? So all of these are available.
Now, do you know why our companies are discouraging premium processing?
So the 1% time we don't file premium processing is because of CSPA. You're able to freeze your child's age for a longer period. So if the kid is already, 17, 18, 19, right? And you're on the border, you're on the cusp of your child aging out. Okay, build up a strong case, file it. Don't get the approval until much later so you can block out that amount of time. That is like one of the only reasons why we do it. I guess one last reason of why people don't do premium processing is to save money. It is like $2,000.
And it doesn't like make your case have a better chance of getting approved.
It doesn't make the case have a higher chance of approval, generally speaking, but in my experience, a lot of the premium processing officers who get it first, they're a little bit more seasoned.
How hard is it to get a 751 approved nowadays?
I wouldn't say the difficulty shot up significantly, right? It's the same officers adjudicating it. They're based on the same standard. A lot of other things surrounding 751 has changed a lot. For example, if they deny the 751, next step to give you the NTA, notice of intent to appear. So that changed, right? That becomes more frightful. At the 751 interview with you and your spouse going to the interview, proving your marriage is real, sometimes they detain you and bring you over to ICE. That's scary, that changed. But the adjudication of the case itself by the USCIS officers, a lot of them are still the same officers. It's judging whether your marriage is real or not. So I wouldn't say that has significantly increased. There are internal policies where they're forcibly, almost lottery style, separating couples to ask them because they're trying to catch fraud. But that didn't make the case significantly harder, because if you have a good case, if you're prepared well, you would be able to ace that anyways. And you should have been preparing for that anyways, even before this administration, right? So, in an idea of building a good case, I wouldn't say it's that difficult. One additional thing is that 751s are taking 3 years, sometimes 4 years to adjudicate. So based on the timing of it, they're using time to kind of weed out real cases or fake cases, right? So in that way, it got harder, but not because the officer is inserting any sort of, new standard. It's just they're using the process to weed out the bad cases.
Here's the person from the 19 countries that are fully paused. Do you think if they get a J1 sponsor from a hospital, they're a doctor, would that fall under national interest exception?
All the national interest exceptions that we filed were in the medical field. So I would highly encourage that.
Have you filed?
Yeah, national, not for the 19th country, because that's very new, but we filed a lot of it during COVID time.
Okay, so, and now they didn't ask this, but now I'm just curious, right? If J1 is not an immigrant visa, so consulates are still issuing J1s, right?
Right.
So if they did a consular processing to get a J1 to come in, that would potentially work?
Right.
As long as the J1 gets approved?
Right.
Okay. Can I naturalize if I had a felony that was expunged 4 years ago?
So expungement is not the most important thing. It's whether or not that felony is an inadmissibility, it's a deportability, right? And so expungement helps, but that's not what the officer is purely looking at.
If you already have filed, how can you change that to premium processing?
Easy. Just file the premium processing, right? Just take the form. I completely forgot what the form is. Take the form, fill it out with the payment receipt, and file it. We do that all the time, and we recommend people do it all the time.
How long should you wait on a decision after AOS interview? To 7 months, no update.
I would say wait a year. We've had clients who had 4 or 5 pending for a year, 2 years. USCIS is just extremely slow, infuriating so. 7 months right now, it's still not that crazy. So maybe wait a year, maybe a year and a half. They might even call you back for a second interview. We've had a couple EB5 investor cases where they got called 3 interviews in 3 years. So depending on your case, complications. If it's super simple, for whatever reason they're taking more than a year, your life is on hold, they haven't approved your work permit, it's an affront to your civil liberties, then do a mandamus and sue them. But 7 months seems still okay for now.
So is it worth the risk to get into the U.S. on the B1 and then apply for AOS to J1? This is the 90 countries. And then also, how can I get a full compensation?
Yeah, so not even part of the 75 countries. And so if you're only limited with such a short amount of time, it makes it increasingly difficult to file a change of status. So all of that being said, I think it's extremely difficult. Now, if you want to book a consultation with us on our website, extremely easy. There's a book consultation with us. You select the time, you make the 250 payment, and then voila, you do a consultation with us. If you only want to do a consultation with me, please specify you only want to do it with Joseph. Then somebody will reach out, rebook a time for you. But again, the way we set up our consultation is for emergency purposes, right? So a lot of people have urgent needs. They want to answer immediately. They cannot wait 2 weeks for me. So a lot of the attorneys, a lot of the account managers at our firm were extremely capable. They can immediately help out.
Okay, to clarify, any bonds for those who were detained, EWI, or anything to get them out if detained?
EWI, intro without inspection, to CBP is a mandatory detention these days. So it's really hard to be bailed out. Now, if you have an I-130 approved, if you have a 485 already in process, if you already have a 601 application prepared, and the ICE officer is willing to let you go through bond process, here's the short answer. I don't think ICE will let you out on bond themselves, because you first go through ICE bond, right? But maybe they will be willing to schedule an immigration bond. And then if you convince the judge, maybe they can make an exception, right? But ICE will not. And with that, thank you guys. Really appreciate everybody joining us here. We'll be posting this later on. Take care. Bye-bye.